Maybe jealous. Also, I have to mention for listing of IA in criminal appeal matter, petitioner behind the bars last 3 years matter, the lifetime life conviction matter,
So,
so many
have conviction 3 years, nothing.
nothing matter. We able to argue this matter matter for bail.
You have filed an application.
I was filed my lot. Date of filing on 17/11/2023.
17/11,
Hi,
2020.
2023.
Okay, when do you want?
My lot 17/10 my lot.
17th and I guess. Okay.
Obviously.
With the consent of the other parties, I recommend item number 4. The amicus curiae is unwell. That's it.
Who is unwell?
Amicus curiae, Mr. N. Hassan.
Hassan, okay, right. Judgment prayer has been made on behalf of Mr. N. Hassan, learned amicus curiae, on the ground that he is unwell. Accordingly, let this matter
After 1 week.
after a week.
Much obliged.
May it please the lordship. Should I beg to mention item number 6, lordship. Adjournment slip already been circulated.
Why? What is the ground?
Lordship, could not prepare, brief could not prepare.
Could
lordship.
not be prepared. You could have, when you submitted this slip yesterday,
Yes, Lord.
you could have prepared it here last night. Even we read it only last night. Okay, right. On the prayer for adjournment made on behalf of Mr.
A.K. Gupta.
A.K. Gupta, learned counsel for the appellant, who apparently did not have time to prepare.
Lordship.
Huh?
Lordship, right. Simple adjournment, lordship.
Who prays that the who is purportedly having some personal difficulty. List the matter
After a week, lordship.
after.
Obliged.
Yeah, please, your lordship. Lordship, I want to mention regarding listing of IA for bail, lordship, on Friday, lordship.
If I may bring for the respondent in this case.
Here for the respondent.
Not, sir.
What do we do? What is the case?
Not,
What is
sir,
the case?
the CSET has rejected their application. Actually, they are availing exemption under notification at 20 of 2008, not sir. As per the notification, they have to avail the exemption by paying the by paying the PL, then up to the after case. But see, what happened? They forgot some machinery and they took exemption in the first year. And second year, they filed that wrongly they have assigned. The tribunal did not consider their application and it was rejected. Question was framed by this honorable court.
So this Senvat credit is an exemption or what?
It is, there is an exemption, lot. So they are entitled exemption under notification 10 of
But prior to exemption, yeah, they've got to follow,
Yes.
follow certain procedure.
certain procedure.
So that has not been followed.
That is not been followed.
What to do? They're not here.
What's it may taken after vacation, lots because the council is regularly appearing.
Okay.
But today, let's see.
Okay, right. No one appears for the appellant, while Mr. Kal appears for the respondent. In the interest of justice, list the matter again on
After vacation, what's in the first
after
paper.
the vacation.
Not much of.
4 of? After that, after 20.
Much.
You're for which one? Both.
I'm for item number 2,
You're for item number 2.
accused Nippon Fukan.
Okay. And Ms. Sharma, you're for item number 3. Both under 30234.
303.
30234. Okay.
I'm appearing as an amicus,
So there is a basis is what? Oral dying declaration.
oral line declaration.
How many witnesses have heard it?
4.
4.
Particularly
How many prosecution witnesses are there?
11.
11. So 4 PWDs have heard the oral dying declaration.
Yes. Yes.
And are they all related to the disease?
They are related.
All 4 are related to the disease. How are they related?
One is the wife,
Wife,
2 is the cousin brother, 3 is the brother, and 5 is nephew.
so what was the reason for the assault?
That's all. According to the dying declaration, after his dinner, he had gone out to buy betel nut and have leaves. So then he met these 2 accused. They were under influence of intoxications. So, and there was alteration because altercation because the victim had asked them to go to home instead of treating nuisance there. It is then that because of that, then they stabbed him in the intestine.
In the intestine. What do you mean intestine? Stomach.
Stomach. Injuries in the right side. So
So how old was the deceased?
this one. 20. Page 39. Page 39.
41 years.
41. Deceased was 41.
Hmm.
And this appellants are how old?
Your lordship, if page 39, age 20 at the time.
At the time.
Deceased.
Huh?
Deceased was 41.
40. Right.
For accused persons were?
Young, 20. 20 and 24.
19 and the one maybe 20.
Of 1 year.
No. 20 and 24 and 19 and 23.
Because this is the recording of a deposition is after 1 year.
So 19 and 23. Yeah?
Yes, 10, 19 and 20.
So seems quite plausible. They're not good friends or something, good buddies or something. And young, hot-blooded person, drunk. Okay, anyway, just wanted to know, have an idea. It usually happens. An elder person will tell a younger person, go home. And then when young persons are drunk, they don't care about respect anymore. Happens in just visualizing a situation. I can understand if the deceased was a young person, same age, then there might have been something different. But here, 41-year-old telling a 19 and 23-year-old, go home, and these persons attacking, quite plausible. I'm not saying that it is proof, but quite plausible.
But still,
Ah.
in the IO's evidence also, there are some contradiction that have been pointed out.
Okay.
But if, as an amicus, if I have to say that part of dying declaration in the cross-examination or the IO's contradiction that have been pointed out has not been able to demolish. There may be some contradiction which may be
Here and there, there
here
is.
and there, but that dying declaration has not been able to be demolished by anyone. So that remains intact.
Okay.
And there has been a specific dying declaration regarding the kind of weapon use also. So accordingly, my focus would be whether it is murder or it falls under exception at exception 4 of 300. And accordingly, there should be,
What? 4 is what?
if it is a sudden hit.
The first one is provocation.
Yes,
So which exception are you relying upon?
relying on exception number 4, because if it's a sudden quarrel,
Sudden quarrel.
then it comes with the exemption, then whether they should be punished under 304 part 1 or part 2. I would try to convince upon your lordship part 2 because it's only single blow. There's 2 injuries, one on the
Single
thigh,
blow with what? Single blow with what?
single stab,
Oh, with a knife.
knife. Then I have 3 judgments to support that contention. The other injury is on the thigh. So that is a non-vital.
Injury on thigh, that means 2 blows.
Two.
So not one.
Non-vital part.
Okay. So they've been in jail for how long?
They were almost 7 years, 8 months because they have not been on bail.
Okay, let us see.
Yes.
Let us go to the FIR.
FIR. Page 1.
FIR is filed by whom? PW?
1. Wife.
Yes.
Yeah, page 1, it is 24/1/2018. The information received is 24/1/2018. 11:20 is the time. Date of occurrence is the previous day. Page number 4 is the relevant part.
Yes.
Humble submission is that around 8:30 p.m. on 23rd January 2018, while my husband, Bimal Saikia, son of so-and-so, went to purchase betel leaf from a shop, the accused persons confronted my husband in front of the gateway of their house, randomly assaulted him with a sharp weapon, and thereby killed him. People apprehended the accused person at the place of occurrence, assaulted them, and then handed over to the police. Accordingly, charge was framed. Page 9 is PW1.
Did they know each other?
They're
They knew
from
each
the-
other.
They're from the same village.
Versus village. They knew each other. Any previous enmity?
No, that has not come in the evidence.
No. So why did they kill just like that?
And
Ah.
from where did they get the weapon is also because to carry a knife, if it is a stick, one can, but if they're carrying a knife and they're under the influence of alcohol, but there has not been any testing done also.
Okay, let's see.
Yes. PW1, page 9.
Yes.
I am the informant. Exhibit 1 is the Ejaha that I have lodged, and Exhibit 1 is my signature therein.
I am
I-
the foreman. Yes.
Yes, I know the 2 accused persons who are present. Deceased Bimal Saikia was my husband. Around 8:30 p.m. on 23rd January 2018, the incident took place. On that day, my husband went to purchase betel leaf from a nearby shop. At that time, the accused persons under the influence of liquor were making nuisance on the road. My husband asked them to go to their home instead of making nuisance on the road. At that time, my husband called me as I am dying. I immediately went to the place of occurrence and found my husband lying in a pool of blood under the bridge. When my brother-in-law, that is PW3, Benudhar Saikia, alias Pulin, who accompanied me, flashed a torch he carried with him. The accused person fled from the place of occurrence. Seeing my husband in that condition, my brother-in-law and I thought that my husband was alive. As my brother-in-law and I could not lift my husband from that state, I went to the house of Pradeep Saikia, he is PW2, in a run and called him to the place of occurrence. After arrival of Pradeep Saikia, we somehow managed to lift my husband's dead body to the road from under the bridge of Changi. On a Changi. In the meantime, many people gathered at the place of occurrence. When I asked him as to who had committed the incident, my husband replied that the accused person, Pittai, that is Nippon Fukan and Praveen Fukan, had committed the incident. Half an hour after, my husband passed away. Here they have said this contradiction is that they are saying they've lifted the dead body from under the bridge to the road, but now the dying declaration was where? And that remains crucial. And thereafter, she goes on to say that he died 30 minutes thereafter. He has been lifted from under the bridge to the road. And if they need 3% to lift, the person's weight has become heavy. So in a cross-examination, I did not witness the initial part of the incident. Today, I have forgotten whether I stated before police or not that the accused person under the influence of liquor were making nuisance on the road. It is not a fact that I did not state before the police that my husband had asked both the accused person to go to their homes instead of making nuisance on the road. It is not a fact. They all may deny it.
And let's go to the next.
Yes. PW2. Pradeep Saikia. I know the informant. She is a relative of mine. I also knew the deceased Bimal Saikia. I also know both the accused. Around 8:30 p.m. on 23rd January 2018, the incident took place. At that time, informant Rumi Saikia came to my house in a run and informed me that someone had inflicted cut injury to her husband. Immediately, I, along with the informant, went to the place of occurrence and found the informant husband Bimal Saikia living in a moribund state under the bridge. At that time, the informant Rumi Saikia, Putu Saikia, the younger brother of the deceased, Bimal Saikia and I were present at the place of occurrence. Along with that, some villagers gathered there. Seeing injured Bimal in that condition, I asked him as to what had happened, whereupon he replied that Pitai and Birai, that is the accused person of this case, namely Nippon and Praveen, inflicted injury to him with a white knife. Seeing the condition of the victim critical, we immediately lifted the still body of the victim to the road from under the bridge with the help of the Changi. At that time, the injured person was alive. But about half an hour after that, the injured Bimal Saikia succumbed to the injury. When I asked the injured as to why the accused person had assaulted him, I came to learn from the injured that after having meal, he went to the road to get some bitter leaf, that the accused person under the influence of alcohol were making nuisance on the road, and that as he asked them to go to their home instead of making nuisance on the road, the accused person inflicted grievous injury to Bimal Saikia with a knife, which led him to such a condition. Police questioned me regarding the incident. As per my knowledge, the police seized the knife that was used in committing the incident. I saw that knife and today. I have seen that the knife in the court along with the matchbox. Police seized the knife and the matchbox from the Pidali. I saw the knife stained with blood. There is some clarity in his evidence, sir.
Is there any enmity between the witnesses and the appellant?
That has not been put in the cross-examination and that has not come in the evidence. And regarding the state of mind of the deceased has also not come in the evidence, because that is also vital, whether he was in a state to give dying declaration or he was in his mental state was such that he can give clear dying declaration. That has also not been put into cross-examination.
But why would he tell a lie?
So that's why so see, PW2's evidence is clear. Though PW1 is saying that he had already died but PW2 is clear and that part remains. So in that situation, that's why my argument would be, since it is in a fit of anger or it is a sudden fight that had occurred between the victim.
But where do you get that from?
From the evidence of PW2 and 1 itself. Because since he had asked them to go to their home instead of creating nuisance, they then suddenly stabbed him.
But where is the argument there? Where is the argument? It is just an advice which they did not follow.
Right. So it's
That whether exception can be attracted there.
they had taken offense on the advice that instead of creating nuisance and drinking alcohol here, go home.
Correct. Correct.
So
Whether that can justify killing someone?
that cannot justify.
No,
But whether that comes under 302 intention to murder or
no, you see, let us see section 300.
yes,
Exceptions,
Except.
exception. Which one are you talking about?
300
300 is exception, which one? Four.
4.
Read it. In a sudden fight.
Also one, if there is a provocation, the provocation is that he has interfered in their
How, where is the provocation? Provocation would be like supposing, say, he sees his wife in a compromising position with someone. That is provocation. Not when someone tells you good advice, go home early, eat food, go to sleep. Those are not provocations. Those are just advice.
that.
Imagine I go out and I see some young fellows, supposing I see them misbehaving with people and I tell them, go home and sleep, you all are drunk. That is not provocation. That is not even a fight. That is not even a quarrel.
Quarrel in the sense, since he has asked them to not to continue the consumption of alcohol in the public road and go home. So there have been exchange of
Where,
That-
where does it say that? There has been an exchange.
because that provoked them. Because that provoked them. In that regard, I'll just
Yeah.
I'll just
Miss Sharma will also have to, we'll have to hear her. Where is this?
yes. In that regard, just one judgment I'll give. Whether that will come under provocation or not. Yes.
So this PW, this oral dying declaration has been heard by PW
1, 2, 3, and 5.
1, 2, 3, and 5.
Yes.
And the weapon has been seized.
But they have all the witness, Caesar witness have denied later.
Okay, and what is your explanation in the under 313?
Simply false.
Simply false. Did you see him, the deceased that night?
That questions and they've denied the incident. That's
So that's all right.
Hmm.
But did you see the deceased that night? Or you were not there?
They've also given false statement, false statement.
Blanket denial.
Blanket denied. That's
So what were you all doing that night? No alibi. You all have not given any defense. You all were not at home eating puri sabji or something like that.
no PW4, if your lordship says, PW4 says,
Ah,
if I may take it. Lordship, that is page 18.
page 18. Okay. 4 says what?
I'll just read that. I know the informant. She is a resident of our line. I know the accused person who are present. They hail from a neighboring village. I also knew the deceased Vimal Sakya. He was the husband of the informant. Now this part. The incident took place last January around 8 p.m. I went to the house of my friend Sri Dulal Gogoi nearby. While I was sitting in the house of Dulal Gogoi, the accused person present hearing, Probin Fukan, as represented by her, alias Biro Bahu, came in shouting and entered the house of Dulal Gogoi. On being asked as to what had happened, he replied that his younger brother, the accused of this case, Nippon Fukan, had killed Bimal Saikia with a knife. He also informed us that the accused Nippon had killed Bimal Saikia under a bridge. I immediately informed the PS. So according to this witness, the other brother came rushing in to say that it is,
Nippon is your client.
yes,
And Nippon, the accused of this Nippon. Nippon. Praveen Fukan.
but then your lordship had turned to page 30, PW9's witness statement.
PW9,
Position, yes,
page 30.
yes. I know the informant. I knew her deceased husband, Bimal Saikia. I know the accused person. The incident took place around 9 months ago, around 8:30 p.m. while I was watching TV in my house. Accused Praveen Fukan was also watching TV. As I was dozing while watching TV, Praveen Fukan left my house. After some time while I was sleeping, I heard screams raised by the informant. Then I found that Praveen Fukan was not there in the room where TV was kept. Thereafter, the informant called addressing me. Opening the door, I did not see anyone outside. After that, I heard a lot of commotion. So this is a contradiction.
There's no contradiction. Where's the contradiction?
No, in the sense, here, the PW9 was watching TV with
Correct.
Praveen
But
Fukan.
then he dozed off.
Yes, then he went out.
When he was dozing off, the accused went out.
Went out.
What is wrong?
No, there is
I
not.
think that
No.
this happened.
Yes, but then he come.
It appears that Praveen Fukan could be innocent of the crime. Could be. Because Praveen Fukan has blamed Nippon Fukan.
Then again, your lordship, this PW9,
But then whether
that would be
accused, evidence of accused,
against another court.
another, yes. What is the value of that? And but where is the question of 34? Does 34 come into play here? Common intention. When furtherance of the common intention.
They were, both of them were present there in lordship.
Present there maybe, but
And
What are the
the name was
judgments?
taken by the deceased, my lord, before his death.
huh?
Their name was taken by the,
Maybe
My
then
lord.
you got only one knife. Or they said, okay, now it's my turn to stab. Give me the knife.
Let us see the postmortem report, your lordship. Let us, see.
One knife.
One night.
lordship, the vital blow, it may not be material in 34. Because my presence is like, if any participation is there, my lord, it is enough.
But then this evidence of PW4 does not indicate that.
But they not examined.
Can both of them be convicted? I don't know. I'm asking. They were both running away.
Yes.
There is now what does section 34 say? Let us see 34. Thirty-four says act done by several persons in furtherance of common intention.
Yes, my lord.
Now, where is that common intention? How do you prove common intention in a case of this nature?
Lordship, then commentary, your lordship, can you have a look? Commentary.
Yes.
If common intention is proved but no overt act is attributed to the individual accused, section 34 of the code will be attractive. Essentially, it involves vicarious liability, but if participation of the deceased in the crime is proved and common intention is absent, section 34 cannot be invoked. That's true. Then common intention means the pre-oriented plan and acting in pursuance to the plan. Thus, common intention must exist prior to the commission.
That
That
must exist.
there. Lord, let us see if any evidence is there.
You see, the evidence is like this.
My lord,
He went out to have pan.
my lord,
Now he saw these two drunk boys.
my lord,
He told them go home,
my lord.
and this time. That's the intention. And I think the seizure was made by one person. I mean, of course, the oral dying declaration says that two of them. What did they say? He found that accused Nippon had no. That is PW4.
PW1, my lord, she is the one. who first arrived. Lordship, the deceased specifically named them. Last portion of examining chief and page 10. He replied that the persons Pitai, Nippon Fukon and Probin Fukon had committed the said incident. And intensity was so much was as a result of which the deceased died instantaneously.
Let us see the medical report,
Postmortem, my lord.
postmortem report.
Page 77. Lordship, page 78. Wound's position and character. On external examination, following findings are found. Stab injury on right side of abdomen or umbilical level away from umbilicus about 2 inches. Stab injury on midway of right thigh. Clotted blood seen. Then, my lord. The 2 injuries, your lordship.
And Caesar is one knife.
Yes.
How will both of them stab? Okay, now it's my turn. Yeah, one will stab the chest, then will say, okay, now it's my turn. Give me the knife. Then
Always they, as soon as the lordship torch was light on them, they fled away.
common intentions.
Then the
Yes,
due to
common
simplicity,
intention.
your lordship.
Common intention and act.
My lord,
Yes,
my lord.
those are two different issues.
But lordship, the victim named these 2 persons, that they are the perpetrators. Whether your lordship will discard and there is no cross-examination to that effect.
The thing is, what to be practical?
I know.
Just somebody says that he has gone to the moon.
But this is a person who is dying, your lordship.
Dying, but matter.
My lord.
If we have one knife, one on the chest, one on the thing.
My lord.
I don't know. No one, I don't know. I don't know if murderers say, okay, now it's my turn to stab. Give me. Supposing there are 21 of them. They now give me one by one, they will do it over. I'm just asking a hypothetical
Lordship,
question.
my lord.
Doesn't seem like.
Then there is no statement to that effect that who has committed what.
You could have found out. PW4 has said, look at PW4 statement. Everything.
Only the Probin came shouting, said Nipen killed Bimal. That would do, your lord, whether it would suffice, your lordship.
You tell me, I am asking you. You are the possible.
Lordship, to that effect, may I assert some judgment, your lordship? Because there is no specific statement from the deceased. He named both these persons. Weapon was one. And your lordship, if your lordship convicts one, whether your lordship believe the shouting or statement given by this one, your lordship. There is one more extrajudicial confession, I know. PW6.
Yes, what does PW6 say?
PW6.
Okay, so both of them had assaulted maybe before stabbing. You see, one thing is,
I know.
there could have been an assault prior to stabbing.
I know.
Stabs may be the ultimate harm fall. But there could have been some fist blows, some slap.
Lordship, here, page 25. It was a statement given before the villager. When the people were, line number 2, when the people were questioned about the accused person, I was present there. Accused Nipom replied that accused Probin had dealt a blow on the head of Bimal Saikia with a piece of bamboo and also stabbed him with a knife. As a result, Bimal succumbed to these injuries.
So yes, so I'm safe by POB 6, but
They're not saved by six.
no, Nipom is
Your name is
Nipom.
Nipom.
Yes.
Nipom replied, Acha. Nipom replied that accused forbidden.
Probin had dealt blow on the head of Bimal Saikia with a
And
piece
it-
of bamboo and also stabbed with a knife.
You cannot be friends. No, you cannot have joint meeting. There cannot be a joint meeting of mind.
in PW 4 is set. The other way around.
Now who to believe? But then in a criminal case, aren't we supposed to decide a matter by coming to a finding beyond all reasonable doubt?
But in order to believe here, only apart from this extrajudicial confession, the dying declaration is there. Whether it passed the test, your lordship, as the Honorable Supreme Court has said. Because there is no cross-examination to that effect, whether he was in a fit state of mind, my lord. And whether the dying declaration is suspicious, your lordship. Lordship, for end of justice, let this matter be taken up on Thursday. We'll have a second look.
Wait, madam, I've heard you. Let us see. Let us see 313.
We want to nothing.
Nothing is there.
One thing.
2%. Reading something for
Yes. Anything else? Carry on. Your judgments?
Friends, whether this is. My submission is that the provocation is that he has interfered with
So according to you, there's provocation.
this provocation.
Interfered with what? Interfered with them getting drunk.
Getting drunk or asking them to leave from the place, that itself is a provocation for which they have got agitated. Whether that is enough to get them agitated,
That does not justify the reaction of having a person with an accused.
yes,
I mean, that was the no one will talk to anybody. When we go for walks in the morning, we'll be scared of saying good morning to the next walker also. One is okay. Yeah, sorry, we are taking.
But here the quarrel took place, the case,
Who said the quarrel took place?
in the case that I want to rely on,
There's no quarrel out.
there was
Right.
hurling of abuses, so they were quarrel, maybe verbal quarrel, but there was. And so whether that would be.
You see, the issue is this. When someone asks you to, some senior tells you or something, hey, you're drunk, go sleep. Meet me tomorrow. Can that be a quarrel? That's not a quarrel, that's an advice given to you. Maybe unwelcome advice. Hey, who does he think he is? He used to be a drunkard during his young days and he's telling me now to not go to home and sleep. Who is he? That is a different thing. But quarreling, back and forth.
And otherwise, the second argument would be they have not been able to prove beyond reasonable doubt as to who had inflicted the stab injury. Or because as per PW 6, it is the other accused.
That's all. No, anything else beyond?
That's all. Otherwise, because your lordship, dying declaration, no one has been able to demolish that. I have to be fair.
Your lordship, first I would like to take your lordships to the judgment, your lordships. In para 29,
Page?
page, your lordships. Page 67, para 29, your lordship.
Yes.
If I may read your lordship.
Yes.
Lordship's para 29, Odin alias Benifer Kutu Saikia is the younger brother of the deceased who stated on being informed by PW1 that something has happened to his elder brother Bimal Sethi. He, along with PW1, rushed to the place of occurrence and they saw the accused persons fleeing away from the place of occurrence with the help of torchlight and found Bimal Sekia lying under the bridge smeared with blood. On inquiry as to who had committed the incident, Bimal Sekia replied that the accused persons assaulted him with a knife. Thus, PW1, PW2, and PW3 have consistently deposed that on the night of the occurrence, that is 23/1/2018, they found Bimal Sekia lying under a bridge in injured condition smeared with blood. And on being asked, Bimal Sekia told them that the accused persons had assaulted him with a knife. It is also the evidence of PW1 and PW2 that after half an hour of the occurrence, Bimal Sekia died. PW1 and PW3 also deposed that they could identify the accused persons fleeing away from the place of occurrence with the help of torchlight. The testimonies of 3 witnesses remain unshaken during their cross-examination and as such attracts confidence of this court. On the other hand, in cross-examination, the defense has failed to contradict the said testimonies of PWs. Para 30, your lordships. The description of the episode narrated by the PW1, 2, and PW3 as aforesaid clearly indicates that the accused persons are the perpetrators of the crime who severely assaulted Bimal Sekia, husband of PW1, with a knife on his body, resulting in his death after half an hour of the occurrence. Your lordships, the learned court below, your lordships, on the evidence of PW1, PW2, and PW3 came to a finding that the appellant along with Nippon Fukan had assaulted the deceased with a knife. In paragraph 29 and 30, which your lordships I have read to your lordships, has clearly laid on the evidence of these 3 witnesses to come to a finding that the appellant and Nippon Fukan are the perpetrators of the crime. Bimal Sekia, with a life resulting in his death after half an hour of its occurrence. Therefore, upon examining the evidence of the aforesaid witnesses, PW1, 2, and 3, we can say that PW1, PW2, and PW3, they are not eyewitnesses, Your Lordships. What I would like to say.
Correct, they're not eyewitness.
They are not eyewitnesses.
There's no eyewitness.
First. Second, Your Lordships, they are related. PW1 is the wife, PW2, and PW3. So, Your Lordships, they may have some ulterior motive.
Oh, you mean to say, just because we are related to the victims, the evidence of a relative is not, is not admissible or what?
Your Lordships, it cannot be, I'm not saying that it can be disregarded.
Then, what is it?
What I'm seeing that the Honorable Court, Your Lordships, in a recent judgment, Your Lordships, I'll say before Lordships, in paragraph, Your Lordships, please tell us the citation. 2023, 19 SCC 672, Your Lordships.
Page?
Your Lordship, I'm handing over the judgment. Lordship.
Give me that. Give me that. Okay, no. Okay, okay. Yeah, okay. Madam, I think these are notes.
Yes. Lordships, from para 42, Your Lordships, para 42, Your Lordships, if Your Lordships would allow me to read from para 42 onwards. Para 42 is relevant, Your Lordships, para 43, and Lordships, 44, 45, 46, 47, and 48. But para 49, Your Lordships, I would like to read before Your Lordships.
You want to read 49?
Yes, Your Lordships.
Okay.
Others are also relevant if Your Lordships want that I can read for Your Lordships. It is noted that great weight has been attached to the testimonies of the witnesses in the instant case. Having regard to the aforesaid fact that this court has examined the credibility of the witnesses to rule out any tainted evidence given in the court of law, it was contended by the learned counsel for the appellant that the prosecution failed to examine any independent witnesses, Your Lordships. Like, Your Lordships, in my case, PW1, PW2, PW3, also PW5, they all are related. PW1 is the wife, PW2 is the brother, PW2 is the cousin brother, PW3 is the brother, and PW5 is the nephew of the deceased. In the present case, and that witnesses were related to each other, this court in a number of cases has had the opportunity to consider the said aspect of related interested, partisan witnesses and the credibility of such witnesses. This court is conscious of the well-settled principle that just because the witnesses are related, interested, partisan witnesses, their testimonies cannot be disregarded, like what Your Lordship say. However, it is also true that when the witnesses are related, interested, their testimonies have to be scrutinized, Your Lordships, with greater care and circumspection. In Gangadhar Behra versus State of Orissa, this court held that testimony of such related witnesses should be analyzed with caution for its credibility, Your Lordships. Para 50, Your Lordships. In Raju versus State of Tamil Nadu, this court observed the sum and substance is that the evidence of a related or interested witnesses should be meticulously and carefully examined. In a case where the related and interested witnesses may have some enmity with the assailant, the bar would need to be raised, and the evidence of the witness would have to be examined by applying a standard of discerning scrutiny, Your Lordships. However, this is only a rule of prudence and not one of law.
So-
It's held in Supreme.
So this is a case where there was an enmity.
Yes, Your
If
Lordship.
there is no enmity, then shouldn't they also be treated as a normal witness?
Your Lordship, I am not on the enmity part, Your Lordship. What I'm
No,
trying
no, you see. The requirement of, the requirement of analyzing the evidence of a related witness, a related with greater scrutiny is relevant, is required when there is some enmity
Yes, Your Lordship.
between the accused and the deceased maybe, or with the witnesses. If there is no enmity, say between you and me, there's no enmity. Why should I say something bad about it? Like that. So why should the witnesses say anything bad or anything false against that accused person when there is no enmity? What justification? What is he going to get out of it?
Your Lordship, perhaps there was no enmity between them. But what I'm trying to say is that the witnesses, the deposition of the witnesses 1, 2, 3, and 5, Your Lordship, they are related. They are related.
Well, so as soon as one gets to know that they're related, you have got to be careful.
No, Your Lordship, I'm not saying that.
You have to say that. That is what
Whether, Your Lordship, the testimonies can be trusted or not, that has to be scrutinized, Your Lordship. Whether it can be trusted or not, in the light of the judgment, of the Supreme Court, Your Lordships, that has to be scrutinized.
But the Supreme Court also said that this is only a rule of prudence and not a rule of law.
Yes, Your Lordship. Twenty 19 SSC 670. Say that one. 2022 670. In Your Lordships, there are contradictions also, Your Lordships.
Okay.
In the statement, there are certain contradictions also, Your Lordships. Because, Your Lordships, if the statement of PW1, Your Lordships, if I can take Your Lordships to the statement of PW1, who is the wife of the deceased.
Yes.
If I may read, Your Lordships.
Yes.
Your Lordships, I am the informant. Exhibit 1 in the is the Ejar that I have lost. And Exhibit 1 is my signature so and so. I know the 2 accused persons who are present. Deceased Bimal Sekia was my husband. Around 8:30 on 23rd January, the incident took place. On that day, my husband went to purchase bitter leaf from a nearby shop. At that time, the accused persons under the influence of liquor were making nuisance on the road. My husband asked them to go to their home instead of making nuisance on the road. At that time, my husband called me as I am dying, Rumi. I immediately went to the place of occurrence and found my husband lying in a pool of blood under the bridge. When my brother-in-law, Benudur Sekia, who accompanied me, flashed the torch he carried with him, the accused persons fled from the place of occurrence. Seeing my husband in that condition, my brother-in-law and I thought my husband was alive. As my brother-in-law and I could not lift my husband from the state, I went to the house of Pradeep Sekia, who is the cousin brother, in a run and called him to the place of occurrence. After arrival of Pradeep Sekia, we somehow managed to lift my husband's dead body. So he was already dead. Here in this first part, she is saying that he was already dead. To the road from under the bridge on a Changi. In the meantime, many people gathered at the place of occurrence. When I asked him as to who had committed, so Your Lordship, when he is already dead, here, second part, she is saying as to who had committed the incident, my husband replied. So once he is already dead,
No,
so there,
the thing is that the evidence has not been recorded in sequence. That's all. So the lawyer is asking questions, saying they're going right to the bottom of the end part, then the middle part. This is tactics employed by the lawyer. That's what you'll do when you go to trial court.
Your Lordship, but there is a contradiction, Your Lordship. Here, first part, she is saying that he is already dead. And if he is already dead, how come he can say that who had killed him? That is a question which Your Lordship has to scrutinize as per the judgment with greater care and circumspection, Your Lordship. And
I thought you were going to harp on the issue as to how did she hear everything and not see the incident.
Lordship, that I wanted to point out because her house is 500 meters away from the place of occurrence as per the sketch. But then
half kilometers on.
half kilometer, whether she will able to hear it or whether that is material, whether she reached first or some villagers have informed her that part. Right.
There is no contradiction to that effect. My lord. It was not put, it was not challenged, my lord.
That's process not.
Whether
done.
at this stage they can take the plea.
No, why can't we look into that issue?
The lordship is a sketch map.
But it doesn't mean that we've got to accept everything that is there. We've got to look at it with a discerning eye and see that if it is plausible or not. If it is totally unplausible, just because it is in the evidence, doesn't mean that we have to accept it. Supposing one guy says, no, sorry, I was not there, I had gone to the moon and back. Just because it is in evidence and no one has contradicted it, does it mean that it is true?
The lordship just see page 85 one. That's true.
Yes.
The sketch map, the complainant house is there, the PW ones,
Which one?
the informant, the down below.
Yes.
That's the house of, that is half a kilometer as per evidence that has come. The PO is a place of occurrence. A house is, that is PW 9 house, PW 9. And PW 8 is B's house. They don't hear when he shouts. They come to know later. But he hears and she goes along with PW 3.
Where does it say it's half kilometer away?
Yes.
Oh, PWA Dalimit Auntie B. She heard south of Bimal Soikia.
Hmm. I'm not that.
My lord.
That complainant
Yes.
was how far away from the place of occurrence?
That I-
The informant, I mean.
Yes, ma'am.
Page 16,
15.
16. That is PW 3. Because PW 1 and PW 3 goes together.
Yes.
In the cross part, your lordships.
Yes.
The place of occurrence is about half kilometer away from our house. I came to know about the incident from my sister-in-law. I have not seen as to who had committed the incident.
But
I saw
this is by PW3. I'm talking about PW1. PW1 is the white.
PW 3 and 1 goes together.
PW 1 and 3 also went together to the place of the incident.
PW3, Uttu Benador. Mother-in-law, Benador. Rest toss and territory.
And the lordship sees page 28.
Where was she? Where was this PW1 at that time? Prior to going to the place of occurrence.
She was at her place.
Her place.
At her
Yes.
house.
Now,
South, my lord.
no. Before that, he says that on that day, my husband went to purchase beetle tea from a nearby shop.
Yes.
At that,
It's nearby. The place of occurrence is nearby. Shop was nearby. The incident occurred when he asked the accused person to
how
go
do you,
home.
nearby means how near?
The sketch map doesn't say anything. So it's
But
very difficult to presume.
PW 3 says half a kilometer.
PW3 says half a kilometer.
And your lordship says PW 8, whose house is near, is shown as to be near to the place of occurrence as per the sketch map. PW 8 does not say that she heard the victim shouting.
PW?
PW 8. She says she heard the wife shout.
Half a kilometer is quite
No,
far.
no,
But-
hard shouts of Bimal Saikia, PW8.
Bimal Saikia's
My
wife-
note says so.
No, no, I heard the sound of Bimal Saikia's wife shouting.
PW8.
You see, I can understand in a village, it's very quiet and you can hear people talking, no doubt about it. You can hear people talking maybe around 50 meters away, might be able
Lordship,
to hear them
Yes,
murmuring.
it's a winter night,
Maybe, madam,
FIR 24.
kilometers is a long distance. Unless they are shouting with at the top of their voice.
Lordship, a person is dying, 2 persons have attacked.
No, I'm not on that. I'm not on that. But, how does she know that they were making a nuisance? And that the husband had asked them to go home instead of making a nuisance on the road. How did she hear that? Half a kilometer away. From here to be half a kilometer, supposing you go towards Iran Bazar. Iran Bazar will be how far? Little less than 1 kilometer. Less than 1 kilometer. So even if it's 1 kilometer, say Iran Bazar is 1 kilometer, half will be how far? It will be across the traffic
Yeah, your lordship.
light.
Winter night, less maybe lordship people, 8 o'clock, my lord, 8:30. And he was screaming, your lordship.
and
Obviously, they'll hear your mouth.
And this is which place? Which place? Lakhimpur. Lakhimpur is a plain area or a hilly area? Plain area. You see, hilly area is okay. You are here on top, you can hear people down like that. If there's plain area, half a kilometer is quite a distance. I'm just, we're just speculating.
Madam.
Yes, Ms. Sharma, anything else?
Your Lordships may mark the paragraph, Your Lordships have.
What paragraph?
Your Lordships of the judgment, para 42 to 50, 42 to 50 is relevant and 51, 52 and 55. Your Lordships. Para 42 to 50 and 51, 52 and 55 are the relevant paragraphs.
Yes.
Lordships, now, Your Lordships, the learned trial court has also passed a judgment on the basis of the dying declaration, Your Lordship. This is my second leg of argument. So, Your Lordships, dying declaration, Your Lordships, it cannot be relied as because, Your Lordships, first, Your Lordships, there are 4 points which I would like to narrate before Your Lordships. First is that the dying declaration cannot be accepted because it was made by PW 1, 2, 3, and 5 who are relative of the deceased. This is the first point, Your Lordships.
Yes. Second.
Second, Your Lordships, is that there is no evidence regarding the mental fitness of the deceased. All the 3 witnesses have only said that the appellant and Nippon Fukan has murdered the victim. But there is no evidence regarding the mental fitness of the condition of the deceased.
Did you question
Okay.
the witnesses regarding this aspect? Did you take up this point at the time of questioning the witnesses?
This point perhaps might not be taken up, Your Lordships. But what I'm trying to say,
How do you say that he was not mentally?
Your Lordships,
Can you
the
come
learned
to-
court below has come to a finding on the basis of the dying declaration only.
Correct. No, what I'm saying is, we are basically trying to speak the person who gave the dying declaration. There is no proof that he was mentally capable of doing it. Okay. Okay. Giving the dying declaration. If you had a doubt as to his mental capability, should you have cross-examined the witnesses on this score?
Yes.
Yes. how do you now say that the maker of the declaration, dying declaration, was not mentally sound? How do you say that? Or mentally fit? Can you speculate? Can we speculate on the in the absence of any evidence or cross-examination to that effect? Okay, next point. So there's a second point. Then third point.
Your Lordships, there are possibilities of prompting and tutoring, Your Lordships. Since there are no independent witnesses, like I told Your Lordships, there are no independent witnesses. 1, 2, 3, and 5 are rated who had seen the deceased making such statement to the state PW. So it cannot be said as a matter of fact that the statement was not a product of any tutoring and prompting by any of the
Tutoring
state.
to achieve what? To achieve what? What is the goal to be? What is the thought? If there is no enmity between the parties, why should there be any prompting or tutoring?
Your Lordship, if there is no enmity between the parties, Your Lordship, then why, Your Lordships, the statement, it does not, there are contradictions in the statement.
Minor discrepancies.
Yes, Your Lord.
So minor discrepancies, if they don't go to the root of the matter,
And in fact, Your Lordship, PW1 at one place, she's saying that her husband died. Thereafter, she is saying that when I asked him, when he's not alive only, then how can he make the dying declaration? And the learned court below has, in para 2930 specifically has relied on the dying declaration. On the basis of the dying declaration only, the accused has been declared as the perpetrators of the crime. So, in that regard, also, Your Lordships, I would like to place one judgment.
yes. But he has not given the fourth ground.
Fourth, Your Lordships, is that there is no evidence that the dying declaration was voluntary. And it was not forced upon the deceased.
He's dying. He's dying. He doesn't need a certificate of voluntariness. He's dying, madam. No one's going to ask him if you don't tell the truth. I'm going to send you to jail. He's going to go and make his maker now. He's not worried about going to jail or something like that. Or getting beaten up by police. Anyway, so not voluntary. No proof that it was voluntary.
PW1, PW1, but I have missed the one line. Seeing my husband in that condition, my brother-in-law, and I thought that my husband was alive. So that is the main issue. He was alive at that time. But the word death, somehow it has come, but he was alive at it. That is the then this 48 years, that line is the proof that he is still alive. So that's why. Dead body is come somehow it has come, I think, but he was alive. As per their presumption, he was alive.
Your Lordships can see that there are contradictions also.
No.
Even though
The question is that he was alive at the time, as per their assumption also he was alive. So then he brought in that.
Yes, what else? The judgment. And will it be evidence? PW1.
Lordships is a 3 judges bench judgment on dying declaration, Your Lordships. 2023 SCC online SC 1060. If I may take Your Lordships to para 62. Para 62, Your Lordships, basically lays down certain parameters for a dying declaration, Your Lordships. But para 63, Your Lordships, I would like to read. If I may read, Your Lordships.
Yes.
It is the duty of the prosecution to establish the charge against the accused beyond the reasonable doubt. The benefit of doubt must always go in favor of the accused. It is true that dying declaration is a substantive piece of evidence to be relied on, provided it is proof that the same was voluntary and truthful, and the victim was in a fit state of mind. It is just not enough for the court to say that the dying declaration is reliable as the accused is named in the dying declaration as the assailant, Your Lordships. Para 64, it is unsafe to record the conviction on the basis of a dying declaration alone in the cases where suspicion. Lordship, here the case, I can point out that there is a suspicion because PW1 statement, again, Your Lordships, I would like to draw Your Lordship's attention. One hand, she's saying that he already, my husband's dead body. Second, again, she's saying that Your Lordships, her husband has made a statement. If I may read Your Lordship, para 60.
Assembly suggests that the deposition of PW1, it is not Mori Thoka, it was Pori Thoka, that was still there only.
Oh, wrong
It's wrong interpretation.
translation.
Mori Thoka, it was Pori Thoka.
My lord.
Could not read and then,
Yes,
so it was there, it was Pori Thoka.
yes,
not
my
Mori. That is the proper,
my lord.
you can see.
PW2 also gives a detailed description.
Serial line. এটকা বুলি অনুভৱ কৰি উঠাব
এই সময়ত স্থানীয় স্বামীয়ে মৰিলো ঐ ৰুমি বুলি মোক মাতে লগে লগে মই ঘটনাস্থলীলৈ ৰাওনা হওঁ আৰু স্বামীক দলঙৰ তলত তেজেৰে লুতুৰি পুতুৰি হৈ পৰি আছিল দেওৰ ৰূপে পুতুৰ হাতত লৈ থকা ইয়াত আছামী ঘটনাস্থলীৰ পৰা পলাই My lord, it was lying.
second line, then it was dead.
মই আৰু মোৰ দেওৰে স্বামীৰ অৱস্থা দেখি তেওঁ জীয়াই থকা বুলি অনুভৱ কৰি মই আৰু দেওৰে স্বামীৰ পৰি থকা অৱস্থাৰ পৰা উঠাব নোৱাৰি মই দৌৰি গৈ প্ৰদীপ শইকীয়াৰ ঘৰৰ পৰা প্ৰদীপ শইকীয়াক মাতি আনো
That is পৰি থকা,
মাই ল
not
নট মৰি থকা মই
Translation, Your Lordship.
translation was not.
That's why I wanted a clarification. So it's, that has been clarified? That point gone. Okay, so translation wrong. Translation of PW1 evidence wrong. So there is no contradiction. Okay. Anything else, madam? Then yes,
Para 64, Your Lordship.
64 years.
It is unsafe to record the conviction on the basis of a dying declaration alone in the cases where suspicion, like the case on hand, is raised as regards the correctness of the dying declaration. In such cases, the court may have to look for some corroborative evidence by treating the dying declaration only as a piece of evidence. The evidence and material available on record must be properly weighed in each case to arrive at an appropriate conclusion. The reason why we say so is that in the case on hand, although the appellant convict has been named in the true dying declaration as a person who set the room on fire, yet the surrounding circumstances render such statement of the declarants very doubt. Your Lordships, again, para 65 tells, para 65, Your Lordships, in Sujit Biswas versus State of Assam, 2013-12 SC 406, the court, while examining the distinction between proof beyond reasonable doubt and suspicion in para 13 has held as under. Suspicion, however grave it may be, cannot take the place of the proof. And there is a large difference between something that may be proved and something that will be proved. In a criminal trial, suspicion, no matter how strong, cannot and must not be permitted to take place of proof. This is for the reason that the mental distance between may be and must be is quite large and divides vague conjectures from sure conclusions. In a criminal case, the court has a duty to ensure that mere conjectures or suspicion do not take the place of legal proof. The large distance between may be true and must be true must be covered by way of clear, cogent, and impeachable evidence produced by the prosecution before an accused is condemned as a convict. And the basic and golden rule must be applied. In such cases, while keeping in mind the distance between may be true and must be true, the court must maintain the vital distance between mere conjectures and sure conclusions to be arrived at. On the touchstone of dispassionate judicial scrutiny, based upon complete and comprehensive appreciation of all features of the case, as well as the quality and credibility of the evidence brought on record. The court must ensure that miscarriage of justice is avoided, and if the facts and circumstances of a case so demand, that the benefit of doubt must be given to the accused, keeping in mind that a reasonable doubt is not an imaginary, trivial, or a merely improbable doubt, but a fair doubt that is based upon reason and common sense. Para 66, Your Lordships, it may be true, as said by this court speaking through Justice Krishna Iyer in Dharmdas Vadvani versus State of UP, 1974, 4 SCC 267, that the rule of benefit of reasonable doubt does not imply a frail, below, bending to every whiff of hesitancy. Judges are made of sterner stuff and must take a practical view of the legitimate inferences flowing from the evidence, circumstantial or direct. Even applying this principle, we have a doubt as regards the complicity of the appellant convict in the crime. Para 62 to 69 is relevant.
Anything else, madam?
Yes, Your Lordship. Your Lordship, lastly, I would like to take Your Lordships to the statement by PWP. As my learned friend, Your Lordships, has already highlighted the fact that it perhaps may fall under part 2 of section 304 of IPC, Your Lordships.
Why?
Your Lordships, if I may read page number 13, Your Lordships, the statement of PW2, Your Lordships. Page 13, Your Lordships.
Yes.
Your Lordships, Your Lordship, 15th line, when I asked.
Okay, well, in the middle.
Yes, Your
Yes.
Lordships. When I asked the injured as to why the accused persons had assaulted him, I came to learn from the injured that after having meal, he went to the road to get some betel leaf. That the accused persons under the influence of alcohol were making nuisance on the road, and that as he, Bimal Sekhya, asked them to go to their home instead of making nuisance on the road, the accused persons inflicted grievous injuries to Bimal Sekia with a knife, which led him to such condition. So, Your Lordship, here it can be presumed that it is not a case of cold-blooded murder, Your Lordships, but may have been committed under the influence of alcohol, Your Lordships, due to certain altercation with the deceased in the heat of the moment. So, at best, Your Lordships,
May due to certain altercation.
yes, Your Lordship.
What is an altercation? You have to bring it out. You should have explained in a 313 that this was the altercation, but you have denied everything. You had an opportunity to explain as to how it happened, what happened. You have flatly denied everything. Now can you speculate as to what had happened? Can you blow hot and cold?
Your Lordships, 3.
Yes.
Lordship, if I may take Your Lordships to section 304 of IPC, Your Lordships.
Therefore, eh?
Lordship, second part, which says that if the act is done with the knowledge that it is likely to cause that, but without any intention, they may not have the intention to cause that, or to cause such bodily injury as is likely to cause that. So, Your Lordships, perhaps Your Lordships, there may be some kind of altercation, Your Lordships. It's not about enmity or something else, but perhaps there was some exchange of words which might have taken place, which have provoked the
Perhaps.
perhaps.
Now can we decide a case on by using the word perhaps?
Worship, that the prosecution has to prove their case beyond
Okay,
reasonable
one
doubt.
thing. Section 304, part 1 or part 2
Part.
can be applied only after altering 302.
Mhm.
Now, to alter 302, you have the only way of altering it is by applying the exception to 300. 299 is culpable homicide. Yes, 300 is culpable homicide amounting to murder. 302 is the punishment for that murder. And 304 is now for 304 to come in. You have got to say that the culpable homicide did not amount to murder. And for it to not amount to murder, you'll have to apply the exceptions 1 to 4. Either of them. The exceptions of 3 and. So which exception are you going to apply? To bring in 304, you have got to apply the exceptions to section 3 and.
There also the fourth exception.
Fourth exception is what?
If the,
Moral.
if the person committing the act knows it is so imminently dangerous that it must, in all probability, cause death or such bodily injury as is likely to cause death, and commits such act without any excuse for incurring the risk of causing death or such injury as aforesaid.
300, exception 4 says, what does exception 4 say? Read it.
If the person committing the act.
No, read that, read that. It's section 300, exception 4. Exception 4. You said exception 4, no?
Yes, Your Lordship. If the,
It doesn't start with, it starts with culpable homicide.
yes, Your Lordship.
Culpable homicide is not murder if it is committed without premeditation in a sudden fight. In the heat of passion upon a sudden quarrel and without the offender having taken unto advantage. So it starts off with a quarrel. And in the heat of passion, there is a fight. Where is the fight? There's only a quarrel according to you. Where is that fight?
Your Lordship, there, so- Your Lordship, there was certain exchange of words which has,
Word is not a fight. That is a debate problem. You know, fight is not a fight is something like fight is that way. It's not that you go nose to nose and start quarreling on top of your voice. That is
Your
not a
Lordship,
fight.
by certain words also people can be provoked.
Provocation and a fight is different, madam.
Yes, Your Lordship.
Exception 4 talks of a fight.
Fine.
So which exception are you going to apply for converting 302 into 304? You please read the exceptions 1 to 4. 300, section 300.
300.
Section 300.
Yes, Your Lordship. Except in the cases hereinafter accepted, culpable homicide is murder if the act.
There's nothing. The exception 4 could have been applied if there was a sudden fight. Is there some indication that there was a fight?
Okay, even if there was verbal abuses also, that can be taken as a fight, but that has not come up.
Not on record,
The
evidence.
Abuses,
Verbal abuses amounts to a fight.
yes, there's one, that's what I wanted to show.
Okay, there
It has to be provocation, but there is no evidence as such that the disease had provoked the accused persons.
And here also,
It's just, your lordship rightly, lordship observed, it was just an advice.
paragraph 6, here also single blow on chest with a knife. Paragraph 6, a quarrel took place on the spur of the moment. The appellant never expected to meet the disease. When the disease was just passing by the road in front of the house of the appellant, his forehead dashed with the pernala of the house of the appellant, which provoked the disease to remonstrate the appellant. It is evident that there was exchange of abuses. And at that
There is
time,
no abuse,
the
there
appellant
is
gave a
no-
blow with a knife.
provocation, my lord, in the event of the matter, whether this case would come up under exception, my lord.
There's actually abuses, and paragraph 8 is the conviction under 304, in spite of a single blow on a vital body part. Whether that would now amount to exchange of abuses in the evidence, that has to
No, you see, one problem is. So that's one thing. But as per the knowledge, as per my knowledge. To attract 304, you have got to bring the case within one of the accepting of the answer. Section 1 to 5. If you can bring that within those exceptions, then only you can apply 304. Okay, which one do we apply?
our submission is that there has been, yes, they have been provoked because they have been
You
asked.
see, I've never heard of a quarrel being defined as a fight. A fight is not a quarrel.
Some abuses can be provocative.
No, can be provocative, is all right. A provocative abuse, does it amount to a fight? In that case, parliamentarians are fighting every day or what? Huh? They quarrel a lot.
So that's why I have
So you see,
only beyond that.
you see, we could have got 142. And I court, we have to go by the provisions of the act. To apply that, it's not the way how to do. So, how do we apply that? That is a problem.
Otherwise, there's no prehistory of enmity. There's no predetermination of mind to commit a murder. That has nothing come out. Even if we take the dying declaration, it is only because the victim asked them to leave the public place.
No, you see, there are
Stop
things, excepting for culpable homicide is not murder. If it is committed without premeditation, in a sudden, in the heat of passion,
Yes.
on the sudden,
There is no evidence of sudden fight. There is no evidence of sudden
Is-
quarrel.
can it be said that is a fight necessary? You see, you have got to go into this aspect. With Sharma, you also, listen. Exception 4 says culpable homicide is not murder if it is committed without premeditation in a sudden fashion. Okay, now, in the heat of passion upon a sudden point. It does not say in a sudden fight or in the heat of passion. No, or upon a sudden point. It says in the sudden fight, in the heat of passion upon a sudden point. So what it means is, it means sudden quarrel with that. In the heat of passion, there was a fight. And due to which we both. Otherwise, unless you can show us some decision by the people, it is to the effect that there is no requirement to have an actual fight. In the heat of passion, if it happens, one person.
The explanation might be it is immaterial in such cases which party offers the provocation
Correct.
or commits the first assault.
Oh.
The first assault can itself be the sudden fight.
Or commits the first assault means what? That means there were two assaults. It is not a standalone fight. It's not a standalone fight. It is immaterial in such cases which party offers the provocation or commits the first. Okay. I don't know. Can you give us some citation? This aspect. That exception 4 does not require that there should be an active fight. Or that one blow, the first blow is enough. There need not be any second blow from either of the parties. Then we'll hear you, madam, yes, you can. Anything else, Ms. Sharma?
Yes, Your Lordship.
Finish. You finish?
Yes, Your Lordship.
I'll harp on the evidence of PW 1, 2, 3, Your Lordship, and 5. There's unshaken oral dying declaration, which was not challenged by the other side, my lord, and which passes the test of lordship credibility, my lord. So in the event of the matter, lordship will rely on the dying declaration to be trustworthy, my lord. And apart from that, there's extrajudicial confession made before PW6. Not before the villagers.
What about, no, villagers are not a party here.
Villagers are not
They're-
a party.
They're not, they're not.
Lordship, as your lordship made a query from half a kilometer, whether anything can be heard, my lord. Lordship, may I take your lordship to the evidence of DW1, which they are not making the submission to that effect, page 37. DW1 also.
Just a- DW1,
DW1.
there is a DW.
I don't know, my lord, how come?
Lordship, what has happened? I'll tell you.
PW9 is
That
DW1.
evidence in my humble submission is to be not to be taken into account because PW9
It's
was
PW.
deposed as prosecution witness.
Yes.
I don't know how he was allowed to depose.
Oh,
against
well,
such-
yes, the same witness, my lord.
DW9 is DW1.
Yes,
Yes, Your Lordship.
that's why the defense witness was not regarded, taken into account by the trial court.
Yes, sir, same person. But I want to lordship submission, make the submission to that effect. He heard the shout. His residence is about half a kilometer away. So when he heard the sound from a half a kilometer, he being DW1, how can the other person PW1 happens to be the wife of the
Guy is hard of hearing. He needs hearing aids. How to win?
but he heard the shouts, my lord, and he came out.
Who heard this?
This DW1, Krishna Tanti.
So he heard, but the others can't hear.
No, I was making a submission. It's very much possible that the wife of the deceased person clearly hears about the shouts of the deceased as well as the noises which has been taken place due to fire. Lordship, due to the whatever was going on between the parties here, Lordship. My lord. Regarding the reliability of oral dying declaration made before the relative witnesses, may I take your lordship 2013 to SCC 81.
To SSC 81.
Yes, my lord.
Para?
Parbin Ali and another state of Assam from 11 to 21. 21 specifically says, your lordship, coming to the case at hand, the wife, the father-in-law, and the two other relatives have clearly stated that the deceased had informed them about the names of the assailants.
2014.
Nothing what has been elicited in the cross-examination. They have deposed in a categorical manner that by the time they arrived at the place of occurrence, the deceased was in a fit state of health to speak and make a statement. And in fact, he did make a statement as to who assaulted him. Nothing has been suggested to these witnesses about the condition of the deceased. As has been mentioned earlier, PW4, the doctor who had performed the postmortem, has not been cross-examined. In this backdrop, it can safely be concluded that the deceased was in a conscious state and in a position to speak. Thus, it is difficult to accept that the wife, the father-in-law, and other close relatives would implicate the appellant accused by attributing the oral dying declaration to the deceased, that apart in the absence of any real discrepancy or material contradiction or omission, and additionally, non-cross-examination of the doctor in this regard makes the dying declaration absolutely credible, and the conviction based on the same really cannot be faulted. And I'll be relying on two more judgments, my lord, on the oral dying declaration. One is it's a Supreme Court India judgment, your lordship, AI 2024 SC 2682. I have taken out the citation from the Manupatra. Manupatra is 25 to 35, your lordship, para. Party's name is Rajendra versus State of Maharashtra. another judgment, Your Lordship. AI 2022 SG 3341. Kamal Khudal versus State of Assam, here para 19 to 25. On the reliability of oral dying declaration.
No, so this Rajendra is which paragraph?
Rajendra, my paragraph from Manupatra Mala para 25 to 35. Isa? Oh. Okay.
How does it start? The para?
Para 25, my lord.
Yes.
Lordship. It has been marked, my lord. The law relating to dying declaration is now well settled. Once a dying declaration is found to be authentic,
25.
235. Itu pala.
And in this last one,
Last one, my lord, my paragraph would be 19 to 25. It may vary in the citation, my lord. It's from Manupatra. Paisa? Various maxims has been quoted, my lord, on the dying declaration. Nothing has come up on evidence that there was any prior enmity or anything, my lord. Why would the deceased person, the person dying, would name this to accused person, my lord, without any reason, your lordship? Since they are the perpetrators, you know, and other aspect is, their lordship, nothing has come up on evidence. There was any lordship, there was any fight, there was any provocation, my lord. So in that event of the matter, whether your lordship will
common
convert.
intention
Common intention, but their presence was very much there.
of the law say. You were the one who read out the explanation.
Common intention, my lord. Nothing has come out, your lordship.
Yeah.
But their presence, they have.
Now, what is the explanation say? We will this will present amount to common intention to approve common intention. Does not.
Lordship, the common intention would come out from the action which attributed by the accused person.
Please give text certificate.
Acts done by several persons in furtherance of common intention. When a criminal act is done by several persons in furtherance of the common intention of all, each of such person is liable for that act in the same manner as if it were done by him alone. Lordship, but here, your lordship, the dying declaration will come, lordship, it will in a high pedestal, because your lordship, the person,
We're not doubting the
My
fact
lord,
that
my lord.
none of them did it.
lordship,
The fact is that to prove common intention, you see, though no overt act may have been done by one,
my lord.
but the common intention requires that the vicarious liability of both the persons have to be proved.
My lord.
How are you going to prove that?
Although intention has has not come up on evidence, my lord.
Intention has to exist prior to the act.
Prior to the
It
act,
cannot be there after the act.
lordship,
So prior to the act, how do you prove the
common
intention?
intention. Because lordship, the deceased advised the accused person to go home, my lord. Suddenly, lordship,
So they both had the common intention to kill.
the double-edged sword, your lordship. Whether in a provocation is there.
That is provocation.
We'll do some research. Let it come up on Thursday.
Why not? Why not common intention killing? It can suddenly spring up at the spur of the moment.
It has to be a, it has to be a pre-arranged plan.
Prearranged plan does not mean it has to be planned 6 months earlier.
No, I understand,
It can come up 5 seconds prior to the
but
incident.
that their motive of they have been actually, they have reacted to the words said by the victim. So
And reacted at the spur of the moment.
reacted as, so there is no pre-arranged plan.
Okay. Let's see. So what, you want to still argue? You want some.
Yes,
I want to pick it.
lordship.
But that aspect, we'll try to find one
When do we hear? Day after tomorrow?
Day after tomorrow.
Thursday.
Thursday, okay.
Thursday.
List the matter. Okay.
In that regard, I've already given one judgment, verbal abuse, but I'll give a. I have the point here.
Yes.
My lord, I'm for the appellant, my lord. I pray, my lord, since he has some difficulty, my lord, on first week of November, my lord. Small case, my lord.
Okay. What is so small about?
Small, my lord, issue is, my lord, regarding identification of the accused person. Issue is small, my lord, but.
It is small, but to have dal roti for the arrest.
Yes, yes. I'm prepared, but my learned friend is.
It's not. Well, it will take some time.
No, my lord, from my side, only 40 minutes, but today he has.
Only 40 minutes.
Yes, ma'am.
That's not.
Possibly fix it on first week of November.
First week of November, any day. Okay, right, on the prayer of the part, this is the matter. On. Third of 11.
Third or fourth of 11.
Fourth.
Fourth, ma'am. Yes.
Give the offense. Any. Three. We put this.
Happy lordship. This is a appeal against acquittal lordship.
Appeal against acquittal.
Lordship.
Appeal against acquittal. Mr. A. Colita's name was shown as an amicus for response number 2. Because appeal against acquittal adversary has to be heard, my lord. Someone is to be appointed.
Correct. So, A correct means.
Lordship.
Oh. Then what to do? We have to.
If his presence is required, lordship, then. Oh,
Come on,
but
judge.
new one is maybe, my lord, appointed.
Otherwise, we could have disposed of.
Lordship. Well, only for 3 witnesses, lordship, one PW 4, 1, 4, and 5 lords. That's it.
According to you, there was one eyewitness,
Yes, lords.
PW4.
Oh, the corroborative witness, lordship. And one PW 1 and 4, my lord. Sorry, 3, 4, 5 is corroborative witness.
4, she's the mother.
4 is mother, my lord.
Yes.
1 is father.
And
Mir
five is
Hussain
my-
gave the first blow. Motive is also there. Quarrel was there.
So who do we appoint? Of the accused, or for the acquitted person. How many acquitted? How many accused? One.
One.
One. My lord, lordship not one. Four accused, one has been declared, my lord, juvenile lordship. Accused number one, Sanidul Islam, declared
So you are challenging the,
Judgment to success.
against whom?
against, my lord, the respondent, all the respondents lordship.
But then if one is juvenile, then how can? you
Yes,
challenge-
lordship.
One is juvenile, my lord, so in that way, they got lordship. Probably that case has also been decided lordship. Now, 2, 3, and 4 lordship. Mohiruddin, Saleha, and Mir Hussain.
No, only one accused. So, as you know,
This case, no, that's it. My lord, only Mir Hussain is, my lord,
only one.
against only
accused.
Mir Hussain is challenged lordship.
They're challenging only,
Hussain.
huh?
Mir Hussain lordship.
Mir Hussain. Okay.
Lordship.
How can you challenge only one?
My lord, against others lordship.
Man, how can you?
Hello?
One person died.
No,
No.
one lordship as part of judgment. Only Mir Hussein's name lordship. May I have to see lordship?
Let us see the judgment.
Yes. Judgment at 6 lordship. Of the memo of appeal. Paragraph 20 law.
Charge was framed only Mir Hussain.
Huh?
Charge was framed only
Yes.
against Mir Hussain.
The other-
And other was, my lord, declared, my lord, juvenile. Against him, I have no silence lawsuit. Now, paragraph 20, last page 11 lawsuit. Against him, finding guilty of lawsuit. Against Mir Hussain, evidence is clear. So, near, my lord, amicus may be appointed lordship. Notice issue was eleven of. That is why lordship, amicus was appointed lordship.
Okay, right. Heard Mr.
Amicha.
Amit Ahmed, learned counsel for the appellant, and Ms. Bibuya, learned at the HNLPP. As Mr. As the learned amicus curiae, Shri A. Kalita has been appointed, has been elevated as a judge of the High Court. The respondent number 2 is to be represented by a new amicus curiae. Shri Mrinmoy Datta is appointed as the new amicus curiae. Registry to provide paper book to the new amicus curiae. This is the matter for hearing when
After
after 2 weeks.
2 weeks, lordship.
After 2 weeks.
Obliged.
Agree, Lordship. A sneer is coming, Lordship.
I'm appearing on behalf of HRH only. He's on left, my lord. Within 5 minutes, he'll be coming back.
What are you
Item-
going to do for the next?
Item 8. Other councils are available, my lord.
I'm for item number 9, Lordship.
Okay. So, the case,
302 months. 302.
no, that is all right, 302. Y'all are all co-accused or what?
Yes, Lordship. I'm for, there are total 10 numbers of acres, Lordship.
How much?
10 numbers of acres, Lordship. And I'm for three acres. Lordship.
Is there any cross FIRs or anything? No.
No, my lord. And my lord, so far, my knowledge goes, my lord, there are some IAs are still to be heard, my lord.
No, it seems we dispose of the main case, the entire thing is finished.
Yes.
Why do you want to do things in bits and pieces?
Lordship, in this case, Lordship, I am appearing for item number 8, Lordship. Criminal Appeal 254, 2023, Lord.
So?
I'm sorry. One is already we have given a list of dates, as your lordship, that will be easier for us now. Item number 4.
Where is the list of them?
We have submitted the other, is it available? The written submission also given a written,
This matter was heard by somebody else earlier.
no, initially your lordship rejected the bail. Your lordship saying that, my lord, that though there are contradiction, it will go at the time of hearing. That's why your lordship, your lordship would have in
No, that, Mr. Counsel. It's a simple question I have asked. Has this matter been heard by some other judge?
not heard.
It has been because they are all notes here.
Yes.
It is not my handwriting.
So,
No, it's all right. I just wanted to know. I'm asking a question of fact. I just want a
Counsel.
straight answer.
Justice Sugana wants, my lord, that
Say that because the notes are here.
I am not sure, my lord, I am just.
I just want to see. I just want a straight answer
Yes,
to the
yes.
question. That's all. Not that I'm running away from this case or something. Yes. So where is your list of dates?
Your lordship will find, I have given, if it is not there, submit for you also, no? No, I thought I read it to us. You have submitted my just step at me. 2 times you have submitted me.
Submission. Yeah, written submission, what is this? This has been heard as well by some other bench. It has been heard at length by some other bench, it appears.
Not at
You have given written submissions, you have given so many things. All this.
No, madam, for the purpose of bail you have given, madam.
Oh,
Last for the purpose bail, not on hearing.
okay.
Today it has come for hearing, but bail is also pending. Now your lordship may take a bail also or hearing also.
If I take up the hearing, it
Yes,
covers
yes.
the basis.
Yes.
And lordship is taking the entire series, then I'll need some time because everybody has to argue. I will give reply to all of them, my lord.
Correct.
It's difficult for me to give one by one, my lord.
Correct.
Kind of. So I need some time if my landlord friend is, because the written argument, if I am not, that is.
No, that I am not
that
sure.
is-
Let
that
me
is
complete our part, then they also
No,
can
I
submit.
am not confused because my landlord senior is pressing the IA or hearing, I don't know.
No, I am, my lord is saying that it is final hearing. It is come for hearing, madam.
It is,
Either that, I am ready for either of that.
see, it is in the hearing list.
Fine.
Okay. There is no point doing things in part.
Yes.
If we hear the IA, it amounts to hearing the entire appeal anyway.
Yes.
Why should we tax ourselves twice?
because my learned friend has referred the written argument, that's why.
The written subject, I can give you, I am having extra copy.
So, yes, so what is the case?
Yes. Now, basically, your lordship kindly,
Hey, where is the paper book? Let us see the paper.
yes. Oh, a report more file to us, no? Me too. Just list of dates, madam, then that will make.
How many paper books are there?
Two.
Why?
Continuation, madam. One paper book, madam, two sets. 412 page, madam.
Lordship, item number 10, Lordship, I would not receive the paper book, Lordship. Item number 10. Series matter, Lordship.
Because you stuck with it. আমাকে পাগল বানিয়ে দিয়েছে।
Item number 10 is connected with the others.
Yes, Lordship. Same judgment, arising out of same judgment.
নাম কি?
After.
হ্যাঁ? আখের আগে। তুমি আছে? একে বুঝিয়ে।
Lordship, generally, when paper book is ready, the registry called to receive the same, but in this case, it was not called us, and I went to the criminal appeal section, they have said that it is in the record.
Several times it was listed, madam.
I don't know, now she's coming, what to do?
I left your lordship, madam, because
And
the matter is pending. Last time they also appeared, madam.
No, you see, the problem is, even if we hear you, then we have got to wait for her to get the paper book, then she'll read, it'll take time. And then by the time she gets ready, we'll have forgotten everything what you
But actually, in fact, they also already appeared, my lord. That question never came, madam.
Good. Yes, why didn't you bring up this issue earlier?
It was on the last 2-3 days before it was ready, as per order, Lordship, I have seen. So it was not informed to us that it is ready, or Lordship, it was not our knowledge. So proceed.
Well, can you day after tomorrow, madam, if that is there, madam, if possible.
Yeah.
If your lordship accommodate her, madam.
Huh?
If your lordship accommodate her, that day after tomorrow, madam. Or it is up to your lordship, because since they know it, my lord, it seems several times, madam, that is coming.
Otherwise, Lordship, with the case report, we are ready, but there is paper book, so we are entitled to. Yes, that is why I'm paying.
Correct. You are in the same boat with him.
Yes, Lordship.
Then whatever he argues, you'll
No,
be.
there are certain allegations which were against him, not against me. So arguments will be different, Lordship.
Then what to do? When do you want it
Uh,
to be ready?
If we receive the paper book today itself, then any other date, Lordship,
Day
the
after
next
tomorrow.
week or day after. Because otherwise we are ready with the facts, but we have to tell you with the paper book. That's it.
You're ready with the fact.
Yes.
How long will you take?
1 hour, madam.
Tell me the truth. Don't say 1 hour just like that. It's
Madam, it is a case, my lord.
like saying 2 minutes, 2 minutes.
No, no, madam, I will not.
Go down.
Well, let me.
No, give me just a rough idea, just so that we can plan. How much, usually around how much? Around? Frankly, around
45 to the, my lord.
1 hour, 1.5 hours. at the
About
most.
45, more than a half an hour.
1 hour, 1 hour.
1 hour, that maximum.
Are you sure?
Yes.
And you?
Now in the same boat, my lord.
You are for item 8.
Item 8 as well as, my lord. Izzat Ali. 11. 8 and 11.
7. And you are for item 10.
Mr. He is also here with me also.
9.
As well as plus 9.
9.
Who is for 10?
10 I have to.
You're 10.
She's for 10.
9. So there are 4 cases.
No, Lordship, 12,
Kotoki is there.
8 to 12.
Who is for 12?
For 11, my lord, S. Nawaz.
12 is P. Kotoki.
Where is he?
He's
No, you see, that is the thing. You see, one thing is that, have you got the paper book? Have you got the paper book?
yes, yes.
You're all ready. 11, 12.
No, we are with same, my lord. Yes.
12 is absent.
Only 12 absent, man.
So 12 is separate, no, represented separately.
My-
Then we have to hear him also.
Yes.
Mr. Akshuman, how long will you take? Approximate. 1 hour? 1 hour. 1 hour, 1 hour, 2 hours gone. And then you will take how long?
Half an hour.
302, no?
Yes.
302, 34.
Yes.
149.
149.
149.
140. Basically 149.
149. There's no cross FIR out here.
No.
No question. When will paper book, they have to get the paper book.
10. Next week.
Okay, right. Miss,
And so
N. Chowdhury, Learned Counsel for the FLN in Criminal Appeal 288 of 2023. Submits that he has not received a copy of the paper. He to furnish a copy of the paper. Just give me item. Let me see. They might be written there in the office now. Might have item.
Oh, my first one. Yeah.
What is the problem? Come.
Only one.
Twelve has also come, my lord. So Kotaki has also
Yes.
come, my lord.
So now all represented, man. So
Mr. Kataki, you are ready.
Yes, but only one witness has.
No, you are ready, no? You are ready. Just a minute. I'm just seeing whether paper book has been given to her or not. Not mentioned yet. So she has to be given. What have I said? To Miss N. Chowdhury. Within?
Lordship, next week.
day after tomorrow, madam, I'm saying, she said, madam, if she get
No,
today,
because paper book has to be given. They'll have to.
not today,
photocopy
she will
and-
get, she says, madam. If she get today, madam.
She will not get today because it is extra copy is not here. It is this many pages.
That is there. If the,
To give her today.
that of course, ma'am. But they can supply, madam. To tomorrow also maybe there, ma'am. Anyway, madam, we have some arguments, my matter is coming again and again, madam.
2023. No. But who will pay for this? They have to pay themselves, no? Who will pay for this? There is no to furnish. Huh? One day so they'll pay. It's too many. Furnish a copy to Mr. Chaudhary. List the matter when? Give it in.
If it is not possible in this week, then 23rd, madam. Tuesday,
List the matter to you.
no? Thursday.
You see, the problem is we didn't want to hear you in parts. Otherwise, we'll hear you, then we'll forget by that time, and then again we'll have to hear same thing. But you can, what we can do is, if you can give us a small, now to take it, but like just point forms.
synopsis.
Already synopsis, I have given again, my lord.
No, no, I don't know. You are saying you're given, I've not even seen your list of dates. You said you gave
There,
list of-
anyway, my lord, again
You
supply.
see, it's like this, what you can do is like,
I did.
like you say, when you your case, you don't make it, don't give us your synopsis of 3-4 pages. Give us in one page. Grounds of challenge to the thing, one sentences. 1 point, one sentence. So that we still have an idea. And you can put your judgment, which para there. Similarly, Mr. Ashuman, you make it short, something like that. And you also. Otherwise, if you put 6-7 sentences on each point, then it becomes, that too. Then, so that it becomes easier for us.
In the list of the, if you give grounds, so then it may make 2-3 pages.
No, don't give any ground. So just say,
Your lordship say that.
just say you are name of accused, case number,
Yes.
grounds of challenge to the judgment and order. Just give number 1. Say challenge to the extrajudicial confession. Yeah.
In this case, only 149 is involved, madam. Only 149.
Just give that, make it
Yes.
one sentence.
Yes, basically.
1 point, 1 sentence or 2 sentences, something like that, and you give a judgment. So that when you make a submission, you make lengthy submission, whatever. But so that straight away we know that okay, this is the point he's going to raise now, and we'll hear you. Okay, we're not going to restrict your submission only
For the purpose,
only
just
for the
giving
purpose of understanding what are the points here.
basic points.
Yes, the basic points that we're relying on. This is the matter on
23rd. Obliged.
In this case, my lord, I'm led by senior counsel Dhisekya. He has left me.
Dhisekya.
Yes, it's against him, my lord, order in appeal.
the correct that
Yes.
you put the money in the
In a
fixed deposit.
Fixed deposit. And it has been shown that, my lord, it has been, my lord, utilized. That was the fault, but it has been rectified later on. And during the revision part, my lord, it was provided before the authority that we have rectified 9A.
What happened?
They hold that, my lord, before finalizing the, my lord, assessment, the assessing authority ought to have conducted an inquiry. On that ground, my lord, review was, my lord, allowed. They
So in this case, what happened, assessment was passed by the assessing officer. It was, he dropped, he is passed in favor of the SSE.
Yes.
Thereafter, the PCIT taken or proceeding under section 262. And it was remanded back to the assessing authority to consider 2 crores of amount which was declared by them subsequently. Then pass order. That was challenged before the tribunal. Tribunal has held that order passed by the PCIT is correct. Against that order, they have position one court. That the authority.
No. So the assessing officer initially in the first order had said what?
He is passed in favor of the department,
Saying what?
saying that the exemption which they claimed is genuine
Exemption under which clause?
under 11(2), section 11
Section 11
of the income tax.
is correct.
Correct.
Now PCIT has
That's section
differed with that on what
Yes.
ground?
And lordship that it is prejudicial to the interest of the revenue.
How?
Lordship that has been mentioned in the order.
Sure.
Lordship.
Lordship will see page 285.
We start from page 273.
Page 25.
The 285 is the
No,
final order.
Let us see the first SSC office.
That has been not been annexed. They have annexed order pass under 263.
Assessment, it will be only calculation part. It won't be a, my lord, detailed order, like assessment treatment. That has been approved.
Okay.
Now, my lord, in the review,
No, sir, assessment with regard to what?
no, it is a normal, my lord, annual assessment. That financial year it has been assessed. We have submitted it. He verified it and he found it to be in order.
Correct.
Only on 3 component, my lord.
Assessment made under which provision?
11(3).
11.
11, second 11.
Lordship will see, my lord, 267. On 3 points, my lord.
Just a minute.
Section 11.
assessment made
Under
under,
section 11 of the act,
under section 11.
on the account of capital expenditure.
Then that was assessment made, order dated by the SSC officer,
15/4/21.
5420.
15/4/21.
Yes, sir.
Now the PCIT order, page.
Page 273,
Yes, sir. It is 23/2/24.
23 to 24.
Revision order, revision order is at 23.
Dated 23/2/24.
Not, sir.
And what does it say? Let us see, where's the
Page 267.
267, 273?
270, in my appeal it is 273.
No, that is a notice, I'm sorry, ma'am. It starts at 273, that is the order. 267 is the, my lord, notice, my lord. There also you will find the three components, my lord, that has been found to be not in order.
273.
267, lord, you will see for a moment the
Yes.
notice.
Yes,
My lord, there are three, my lord, in first para.
yes.
Fresh investment of 2 crores, that, my lord, the amount, my lord, which has been kept as fixed deposit. And TDS, tax deduction at source, that is 6,92,784. And released security deposit of 6,03,133. These three components, my lord, the authorities have founded that, my lord, we are not entitled for that particular exemption at all. So we'll have to pay the tax, my lord. for this
Exemption under what?
But there is a provision, my lord, in the section 11 itself, that, my lord, it will be exempted.
Huh?
It will be exempted
Exempted from what?
from payment of income tax, my lord. And, my lord, so far as this 2 crores is concerned, it is the government of Assam paid release to the, my lord, appellant. So then, my lord, some renovation work can be, my lord, carried out.
It is to be paid, not paid.
Yes.
Otherwise, it was paid, my lord. It was there in the,
It was paid but kept with whose account?
with the appellant's account, in the, my lord, fag end of the, my lord, financial year. So we could not, my lord.
It was kept with you,
Yes,
you.
that's
So
why we
how
kept
can you
it.
say that it is somebody's money when it is still kept with you?
No, not that part, my lord. Regarding TDS and all, my lord, tax deduction as source, security deposit, my lord.
And anyway, can you put government money in fixed deposit?
No, so that's why, my lord, there was a particular provision under Form 9A where we can show it that, my lord, this particular amount has not been utilized, but it will be utilized later on. That, my lord, there was a fault in our part in submitting the Form 9A. That was rectified later on. Prior to the revision order, it was placed before the authority that we have rectified, and rectification has been done in that form from their authority itself, my lord. We cannot on our own
Let
rectify.
us see. So this is, no, what does the PCIT said?
PCIT is lordship, remind to the matter
Eight.
of the SEC of 270.
270, lordship will find the, my lord, final order.
The reason, why? What is the reason? Don't just skim over the issue.
Lordship will see 285 for a moment, my lord.
Yeah.
Only 1 point, my lord. In view of the above, para 8, my lord, 285, in view of the above discussions, the assessment order is held to be erroneous and prejudicial to the interest of revenue without the, within the meaning of section 263 of the Act, since the claim of the applicant of income on account of capital expenditure of rupees so and so, that is the 3 component, was accepted without inquiry or verification. Now, lordship will see, such a claim is not admissible as per the provision of this Act. The issue is therefore set aside and restored to the assessing officer to pass a modified assessment order after affording reasonable opportunity to the assessee. Lordship will see the last part in the light of the above discussion. Now, my lord, that decision has already been taken. They say that this is for this reason we are not entitled. So you just review it and impose the tax, my lord. That cannot be, my lord. The liberty should be given to the, my lord, assessment officer to conduct an investigation, and thereafter he will take his own decision. They said, my lord, in the light of the above discussion.
So what is the discussion?
Lordship, page
Yes.
290.
Huh?
Of the tribunal's order. Page 290, paragraph 9.
290.
No, no,
No, I have the PCIT order.
PCIT. Yes.
What is the basis for not agreeing with the
page
SSC officer?
280.
Huh?
280, my lord.
280.
3 points have been discussed.
Okay.
One, my lord, starts at page 280.
Yes.
It says the claim of capital expenditure rupees 2 crores. Then, my lord, 281, the second point, the claim of TDS as application of income. They, according to them, that is not a, my lord, income. And in 282, the third point, the release of security deposit of rupees 6 crores or 6 lakhs. 3,133 claimed as capital expenses.
The discussion is at page 280.
Huh?
Discussion by the PCIT at page 280.
That's why 280.1 starts now.
There are 3 points. We have discussed.
Possible here as well, let it be.
What is this capital expenditure?
Capital expenditure means, my lord, we have utilized it. Here the term is, my lord, application of income. It says, my lord, the definition is, my lord, that whatever we have earned, how we have spent it, my lord. Now, if it is not spent, my lord, then, my lord, we'll have to pay tax on that, yes, on the income. Which is got left out in by 31st of March, despite earning. So here, my lord, point number 1.
So you have not spent it.
No, they under 9A that can be, my lord, we got that, we can have a, my lord, particular, my lord, benefit of, my lord, this particular, that, my lord, we'll use it in the next financial year. We can disclose it. That was, my lord, probably some error was committed by a chartered accountant while placing the, my lord.
But if they have to
Two
file
crores.
Form 9A
Yes.
within a specified period, but that was filed by them after 4 years, when the notice was issued by the department. Then they try to rectify their mistake.
Okay, anyway, that. Adjournment, so when do you want?
And after Diwali,
Right, adjournment prayer has been made on behalf of Ms. These explanatory.
no, here, my lord, we have been engaged by the authority.
By name your explanatory counsel for the,
Appellant.
Lordship will say, I am praying for adjournment, my lord.
for the appellate.
Yes. Oh, no, I am praying for adjournment instead of his name, my lord. Lordship may record.
Okay.
Today I am praying.
Mr. B. Gogoi, prays for adjournment.
Hmm.
Appearing for the appellate, prays for
Yes,
adjournment. The same not been objected. Leaves the matter after 2 weeks.
After 2 weeks. my lord.
Much.
Well, there is an interim that may come.
Interim order to continue. 3, make it 3 weeks.
No, sir.